This is the Title Abstract, the podcast about the people, tools, and trends shaping the future of title. Title industry is changing fast from regulatory pressure and shifting joint venture rules to new technologies, smarter sales strategies, and evolving customer expectations. We created the Title Abstract as a place to break it all down candidly, practically, and with the people who are actually doing the work. You'll remember our esteemed guest, Jonathan Holfinger, from the last episode, Rob Zwink, our CTO here at Rozzi, and John Dyer up there in Cleveland doing everything good in title. So what we're going to talk about today is the FinCen rulings that are coming down. And, one thing that's happened recently is a group down in Texas, Flower Title Companies, they filed a lawsuit against specifically Scott Bessent. And their claims are the rule oversteps FinCen's authority under the Bank Secrecy Act, and they're violating separation of powers principle. The rule constitutes an impermissible delegation of legislative power, and title companies are being coerced into a form of warrantless surveillance, intruding on client privacy. And those are kind of the three bylaws that they're calling bullshit on the federal government. So I don't think any of us are necessarily studying the lawsuit itself, but I'm just curious for you guys, like, how's this ruling affecting your lives, your work? I know they've been kind of piloting this out throughout different parts of the country. I don't know where they've been doing it. Has it affected Ohio yet? What are you guys thinking
Well,
about this?
it's been going on for a while, and it started. My recollection is it started in Miami and New York City, and the concept was large cash transactions. I think the original transactions were over 1 million cash transactions with an LLC, and then I know it expanded at least to Austin, Texas, because I've spoken to an agent down in Texas and in Dallas Fort Worth area, and there might be other spots, maybe LA and San Francisco, occur to me. That's been a pilot program that's been out there. And now, effective December 1st, this reporting takes place. So if one of our clients buys a house in an LLC or in their trust for over $1 million, there's a host of reporting requirements that we have with the federal government. So for the agent, first off, if we don't comply with the rule, there's criminal liability. That's the number one thing. So it's very serious. The second component that we as an industry are focused on is what exactly do we need to report and how? And so FinCen is working on creating their portal and creating all the forms and so forth so that we'll have the ability to get in front of that. And then the next question is, how are the title production software systems in our world going to allow to be coded so that we can export data directly to this portal if that's possible, or do we have to re-enter the data? And what if there's a typo? And that's a risk factor for us as the agents. And then we have to then get the information from the clients, and the clients may not be too excited about giving all the information about their trust or about their LLC or what have you. And then it's likely that the realtors and the clients will say, well, I'm going to give a mortgage to my Aunt Gertrude, or I'm going to do, and so the rules are pretty clear that none of that stuff is going to fly. So we're like the traffic cop that has to enforce these rules, and we really can't get paid for it, probably. And so, so from my perspective, I am trying to reach out to realty companies to explain what this is, and they do not know. And I wouldn't expect them to know, but they do not know. So I'm trying to get into real estate offices, so especially the offices where they're going to have these large transactions, where people are going to be familiar with it, so that they can set the groundwork for their clients to say, hey, cash deal over 1 million, it's not just to you and your spouse. You're going to need to provide some additional information to the title company that has to go to the government. And nobody likes, I don't think, likes reporting information to the government, but that's the law. And then we have to staff it to get it done. On the positive side, through the Ohio Land Title Association, we were able to, and the American Land Title Association, along with some colleagues in the industry, we were able to speak to people at FinCen. And the main takeaway, they appreciated our concerns. They said, we are not intending on punishing people that are making good faith attempt to comply with the regulation. They understand it's new. They understand, there's going to be a learning curve and all of that. So that was good to hear. They and so, where it's going to end, I don't know. because of other reporting requirements for LLCs about the ownership of LLCs that was, effective at the end of 2024 that got delayed due to litigation, people somehow think this is just going to get kicked down the road, but it's not. I mean, and we have to be ready as an industry. And one of the ironies of doing title work, at least from my company, is it's really hard to get people to give you the information you need to help them close their transaction for whatever reason. People tend to not give you their operating agreement of their LLC or their trust document or what have you. So getting even more documentation is going to be difficult.
Great point. I mean, we've been planning for this to go into effect December 1 for months. And, part of the preparation requires getting different leadership involved across our family of companies with, general counsel and our software experts and some of our regional directors and, discussing what we're going to have to do. How do we start notifying real estate agents about this? Because, that part in particular is tricky, as John was mentioning, that the realtors are the trusted party in the transaction. The actual buyers sellers don't know us from anybody else usually. They don't trust the title company because they didn't reach out and contact us in the first place. So when the realtor or the lender chooses the title company and then we reach out to the party that we need to gather information from, they're probably going to ask their real estate agent, is this legitimate? And so if a realtor isn't good with communication, proactive, upfront, telling them what to expect, that makes our job harder. And it makes collecting that information harder, and it slows things down, which ultimately snowballs into a lot of problems last minute for closings. And so, years ago, there was a lot of talk about making transactions smoother and getting borrowers information ahead of time and kind of having an opportunity to evaluate everything. And I worry about gathering this information will just create more challenges right up before the closing itself occurs. And so, how will this lawsuit affect all of these plans? I think I agree with John that I doubt that it will. I don't know enough about it to say, what's going to happen, but I have to prepare for that not to occur and that for everything to go on as planned and for us to have to gather information reported under FinCen within a couple months here. So if for some reason it gets delayed, that's great, but I imagine it won't just go away, that it would just ultimately get stayed for a little while. But either way, I think we have to prepare for the inevitability of this sort of thing happening because FinCen reporting has been around. So it's, maybe it changes slightly, but I doubt it.
So the lawsuit was filed on behalf of the flower companies by Pacific Legal Foundation. If the Pacific Legal Foundation called you to join a claim, would either of you jump in and?
No.
I wouldn't. Yeah.
Got it.
Not time for that.
That's funny. So maybe Rob, going to you. They're talking about like how this might impact the customer engagement, prolong the closing process. From a tech perspective, do you see opportunities here? Do you know if any vendors are tackling the problem, or what are you seeing on the tech side?
Well, my understanding of the rule is there's a requirement to have a documented procedure in place related to like the collection and storage of just essentially a lot more information. So like an audit log trail. So like simply if you receive an email, you'll have to keep the information related to its receipt and the information conveyed in it. Like there's effectively like a audit log requirements of upon request, you could produce both the process and procedure of how your staff was trained and then a corresponding and here's all of the detail that happened during this transaction. With what I know of, I guess, software in the industry and to an extent the kind of disparate nature of it, like the emails in one area, like order entry in another area, like maintaining that log will likely be manual in many cases. Like I don't know if do you feel like your title production software will support, and it could be you haven't dug into it yet, but it just feels like it'll be fairly onerous for the in-scope transactions to have that level of audit logging based on the software that I am aware of today.
What we're seeing is that our primary production system is not going to adapt to that very well, and that other vendors in the marketplace that have consumer-facing portals are the ones that are trying to figure out how to adapt to it on the tech side.
Gotcha.
Hmm.
So then, yeah, to answer your question, Justin, it feels like there's a gap in that ability to produce a auditable log along with the process, like people process tools that shows, here's the process, here's how people are using it, and something that's auditable so that, title offices can claim that they've put the intent in to comply. Probably there will likely be a bit of a scramble as we approach the end of the year to make sure that those processes are all buttoned up.
As they've been marching towards this December 1 rollout, did you first get like an actual concrete email or disclosure to you of like exactly what you have to follow? And do you feel like you're prepared? And
I mean, I don't think we have that yet because there's no, to my knowledge, the final rules have not been completed for FinCen. So, I mean, we might know statutorily what is required, but the mechanisms to get it into their system, I don't believe that we're there yet. I mean, there are many underwriters and the land title associations, both national and statewide, are focused on this because we're in the final throes of it. And title is you just get busy day to day, especially in the summer, and it's just an excuse, but it's just a fact. And so you don't really have the time oftentimes to focus on these, critical, more long-term plans. So you just like, well, we'll deal with that in November. The day after Thanksgiving, we'll figure it out. And, we probably don't do that many cash deals over $1 million, but we do, we do enough. So we need to know how to do it. That's kind of the nature of it from my perspective. Jonathan, you probably know more about this. What is your understanding currently?
Yeah, I mean, I guess I would say one good thing and bad thing. Good thing is we're big enough that I now have a team of people that are working on it and have regular FinCen meetings and been doing that for months. Bad side is that I actually have an update tomorrow on that, so I'm not current on my knowledge of the latest over the last month or two. But yeah, my understanding is we're going to have to report these all different types of transactions, whether or not it goes through the title company, right? So this applies to lawyers that are doing conveyances where they might say, "Oh, we don't need title insurance if we can get around the rule," and that doesn't really solve the issue. It's if there's a transaction that is being conveyed or people are trying to, put it in or out of their LLC or change things, we're going to ultimately have to deal with it. So a lot more of knowing what we have to report is how much effort do we have to put into identifying transactions that we do have to report.
Federal government can be a bit chatty when it comes to rules and regulations. If we're referring to the anti-money laundering regulations for residential real estate transfers, the interesting things about it is that it also includes vacant land, which is, kind of an interesting designation as it relates to like residential real estate transfers, because then it's kind of like up to maybe some degree of interpretation if it's going to be used for, I think I'm not a lawyer. So
Yeah.
the other side of that is, do you have a process? Have the people been trained on it? Are they collecting like a 10x more information for every transaction? And can you produce it upon request? Maybe there's some opportunity for like industry members to cooperate on a policy that could be adopted. Like it would be a shame if every title office kind of developed their own policy for adhering to the compliance requirement. But yeah, it seems like there's a lot of work there to do.
well, back to people process tool,
Maybe there's
upstream definition of what's required has to be in place before these guys can actually create people processes and adopt tools, right? I
maybe
feel like
from the tech voice here, it would be like maybe not rushing to the tool, like figuring out how to do it manually first. And yeah, I think you're right. It's like we need to get another degree of certainty on what it is.
this is coming down the pipe.
Yep.
I don't know, sometimes the federal government says this date and they push it back. Do you anticipate them
We've
not?
had a history of that in the industry of things that are going to be rolled out and then they get delayed. So, it's possible, but there certainly was a fairly long runway with this, and barring, some sort of injunction that would delay it, we're doing what we can to be prepared. But like John said, summertime's a busy time, and we in the title business, you don't have a lot of luxury of people just sitting around working on projects all day. Most people have to put all hands on deck and working on transactions. So once it slows down, it's a little bit easier to really dig into, okay, when are we going to actually pull all of our employees into training on this topic? And so that's really your timeline for figuring out, all right, when do we need to do this? Is we sprinkle information out there, but ultimately you kind of have to load the training right before it's necessary. So A, people don't forget it, and B, in November, we're going to be a little bit slower and people will actually maybe listen and pay attention in a training.
Mhm.
So maybe that answers my meta question of why I get ghosted on emails as a dude selling software to title companies over the summertime, and might have just given me some clarity. So, any other parting thoughts on this? I think everybody's kind of aware that it's a problem. We're trying to be prepared as possible, but we've got a few other things to talk about too. So, open-ended question: Did you have any thoughts you want to share with the community here?
I mean, the only thing I would say is that, I mean, through the various state and American Land Title Association, there's a lot of information out there. So if agents are not sure about, this, or the first time you're hearing it, or it's there and it's just kind of kicking around, it's time to get active, use the resources available to you to take the next step. And the underwriters are all pushing out information. So there's plenty of resources for all of us. We just have to make the time, and that's part of being the business owner that's got a lot of plates spinning. You've just got to figure out how to do that. And not
Yeah.
all of us are fortunate to have a FinCen team like Jonathan. But one of the great things about our industry, frankly, is that if I called Jonathan and said, "Hey, can you spend 45 minutes with me talking us through that?" He would do that because that's just the kind of guy he is. And I would do that for other agents. We help each other, and we can, because we all have to succeed to have a successful industry. And that's something we're all committed to. So people should reach out to their peer group, and sometimes competitors, but friendly competitors, and make sure you're on the same page. And if and we all tend to help each other, and we're always glad to do that.
Yeah. Well said, John.
We're all
And
in this together, folks.
Yep.
I'd add, from the 13 years JP Morgan, I feel like I spent the early part of my career kind of trying to find ways around and to get things done more efficiently. And then I invested more time into learning the rules, and that's in my mind. I learned the rules in order to play the game and win. And I do think there's opportunity to become more competitive by being compliant, and super efficient with compliance, having a written policy and procedure on compliance, having a named compliance officer. These are things that as a parting thought, especially as I review this ruling, it is significant, and it's reasonable to believe that it's going to take a lot of effort. And I think first two steps, put somebody in charge of it, and then create your own internal document of how you'll comply, and then complain about it at Thanksgiving.
Well, cool. Marching towards December 1. Let's get ready. So this is the title abstract. Thank you for joining us here today. If you found this conversation valuable, share it with a friend, a colleague, an underwriter. Help spread the good news. Thanks, everybody.